Hey everyone, Scott Stork with Polaris Law Group. We're estate planning and elder law attorneys. Today I want to talk to you a little bit about what is bloodline protection. We have clients who routinely give us a call and ask us, how do we keep our inheritance in the bloodline? So what's that mean? Basically, what they're worried about is how do they make sure that if they leave an inheritance to especially their children, how, if their children get divorced or something like that, how do they keep that inheritance from ending up in the hands of their now ex-in-law? So take, for instance, if one of the kids just receives money, and let's say that they do something called commingling it, they mix together their inherited assets, property, etc., with the marital assets that they have with their spouse, and then they get divorced, the issue is that half of that inheritance now is gone in the divorce proceeding, and it's now in the hands of the ex-in-law. And so why that's important, obviously, is people typically want their inheritance that they're leaving to their family to stay in their family. So bloodline protection means the inheritance moves down their bloodline from their kids to their grandkids, etc., rather than outside of their bloodline to somebody that they don't typically want to have that. So it's a very common question. It's a very common concern. We all love our in-laws and things of that nature, but when they're no longer our in-laws, they're typically not someone that we want to inherit our money and the legacy that we want to pass along. So how we achieve that is that we want to make sure that the inheritance never ends up in the kid's name themselves. Now, that's not to say that things can't be protected if they end up in your children's names, meaning in their own bank account, things like that, but it gets really, really precarious as to whether or not those assets and things like that can be protected at that point. So the best way to achieve this is to create a trust that the clients can create themselves. It holds their property, and then what it does is it passes that property on to their children in each of their names. So let's say that you have two children, Joe and Sally, and Sally receives now her half of the inheritance inside of this trust. It's a protective trust for her, and it's not in her own name, it's in her trust, but she can be in charge of it, and she can get to the money if she needs it. But what that trust says is that it's not in her own name, and so should she get divorced, it can't be part of that, or it shouldn't be part of that divorce proceeding. And if something happens to Sally, then she can leave it to her kids, and on it goes. And so what it does is it really creates a measure of protection. That irrevocable protective trust that you leave to your loved ones can stay in your family line. It can be protected from those divorces and things like that. It can be passed along to grandkids. Maybe it has some quote-unquote strings attached to it if you want. It doesn't always have to. But what it does is it makes sure that nobody can come and take that inheritance away from your family, and it really makes sure that what you leave stays with who you want it to stay with. So I hope that helped. If you have questions about how to achieve this in your own situation, please give us a call. We'd be happy to sit down and talk to you about that. Everybody's situation is different. Everybody's planning is different. But we're able to really talk to clients and help them with their specific situations. So you can give us a call here at 636-757-3850. You can also visit our website at polarisplans.com. And we look forward to hearing from you, and we hope this helped.